All right, good afternoon, everyone. Are you able to hear me?
Yes, Your Honor, we are.
Miss Bridgewater, may I have my reset date, please?
Sure, it's going to be November the 11th. I'm sorry, November the 1st.
November 1st. All right, it's now 2 p.m. Let's go ahead and get started. Good afternoon, everyone. I'm Judge Melanie Williams. This is the State Expedited Accusations calendar. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. All participants, including defendants, this particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means that any member of the public can log on and watch this particular proceeding. As those who receive a surety or a cash bond today will be reset to the state all-purpose calendar on November the 1st, and those who receive a signature bond will be reset further notice. I hope that I saw the jail on the screen. I saw South Annex for a brief moment. Is the jail on the line? Have all defense attorneys had the opportunity to speak with their clients?
Wow.
Not sure what's happening today. Ms. McLeod, I see you on the line. Have you had a chance to interview your clients? Oh, you're muted.
I have one. Yes.
Oh, wonderful. Thank you. Ms. Armstrong, have you?
Yes, Judge, thank you.
Thank you. Good to see you both. All right. I don't see the jail on the line, so it may be that I'm making the entire recitation again in a few moments.
Your Honor, while we're waiting for the jail, we do have a couple of announcements.
Please proceed, Ms. Falk. Good to see you. Good afternoon.
Good to see you as well, Your Honor. Position 21, Jarvis Teague, posted bond.
All right.
Position 19, Antoine Sims, a waiver was filed by PD Kim.
Is Ms. Kim on the line? I see her on the screen. We could do that case first.
And position 16, which is Walter Reed, was also filed down by a waiver was filed by PD Kim. Excuse me.
All right. Ms. Kim, if you're here, we will take your waiver cases first. So as
And
not
also,
to wait.
Your Honor, Ms. McLeod filed a waiver. So I have all three.
All right, wonderful. We can take the waiver cases if the jail is not on the screen. I see South Annex. Is there anyone at the South Annex?
Holly,
Yes.
do you know the password? The jail said they need the password. They've been trying to log on.
Oh, okay.
Well,
I
there's
will get
that.
That explains it.
No, it's
Okay.
called the
We'll make
South
sure.
Annex, so they can hop on.
Can we do South Annex? The South Annex is logged on. They just need, can we take the South Annex cases? Is Ms. Kim here?
I don't see Miss Kim.
Miss Kim is
Well,
on the
yeah,
Zoom
she signed
conference.
on, yeah.
She's just not
she's-
here with us. Well,
Well, if I know which case Miss McLeod filed her waiver on, we
Yes.
perhaps start with that.
Position number 6.
Okay.
all right, let's do
I
that
was
case.
on the thing. Hold on.
Mr. Howard is muted, please.
Huh?
All right. We're gonna do the waiver case while you all figure that out. Mr. Howard, can you give us the history for position case, the case of Dustin Godfrey, case number 22 CR 007044E, in which defendant was charged with theft by taking with the offense date of August the 6th?
My coworker got that case because he went to felony earlier. I'll go
Well,
cook it.
that's okay. We'll defer to the state. Ms. Sowry, good to see you this afternoon. Will you please give us the history in that case?
Yes, good afternoon, Your Honor. This defendant does have a 2015 probation violation, 2016 simple battery theft by shoplifting that resulted in a guilty conviction, a 2016 burglary and criminal damage to property that resulted in a guilty conviction, as well as a 2016 probation violation. Your Honor, just 7 months ago, this defendant did get charged with entering auto. That's an open case with the Superior Court, and he was given a $5,000 surety bond, yet he's here today, or his case is here today. He has a theft by possession of stolen mail from 3 months ago. That's an open case in felony court, and he has an open case in felony court, which pretrial has noted. The state's bond recommendation is $10,000 cash, with conditions of staying away from the incident location, no contact with the victim, whose name is Amity, Amity, last name Hill. No drugs, alcohol, or weapons, and that incident location is 3247 Dale Lane, Southwest in Atlanta. Your Honor, briefly, the facts are that the defendant was seen on the victim's Ring camera approaching her home with a bag. He then dropped that bag on the porch and took a package that was sitting on the porch and sped off. Due to the defendant's erratic driving and the victim's package missing, a nearby witness wrote down the defendant's tag, and the tag came back registered to this defendant, and he was identified through his license photo. So again, we are requesting that $10,000 cash bond due to this defendant's lengthy theft history. Nothing further.
All right, thank you. Ms. McLeod, please proceed.
Yes, Your Honor. My client is 27 years old. He is a native of Atlanta. He tells me that he lives with his girlfriend and his 2 daughters. One is 9 years old and the other is just a year old. Your Honor, my client, as the state has said, had some other charges. He went to felony, and I believe he was given an $8,000 good bond. He's not in a position to post that bond. So if he gets another high bond, he will be in an even worse position. My client denies that he stole anything or that he did anything wrong, Your Honor. That's what he tells me. So I'm going to ask the court to take that into consideration, the fact that he is a father, that he has 2 young children that he is taking care of. He also tells me that he is gainfully employed. He works for the city of Atlanta. I'd ask the court to consider all these factors in setting his bond, given the fact that these are just allegations which are yet to be proved and so far have not been proven.
All right, thank you, Ms. McLeod. At this time, the defendant will receive a $4,000 surety bond, and he is to stay away from that incident location on Dill Lane and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thank
Nothing
you.
further from the state.
All right, Ms. Kim, are you with us? Can we do the other way cases, or is the
Yes, Your
jail
Honor.
on the line?
Sure, I can do it, Your Honor. Sorry about
All
that.
right, that's
I
all
have
right.
to
Is
go
the
on the
jail
phone.
on the line first, or we're still having problems logging on? Ms. Bridgewater, do you know if did they get the
Online,
password?
Your Honor. They're
All right,
trying to get the jail on the line now.
all right, let's do the South Annex position. Has the South Annex I don't believe, heard their rights, correct?
No, ma'am.
All right. What position do I have before me?
She's position number 20, Your Honor.
Thank you. All right, I'll do the recitation of the rights as I explained. Are there other defendants there at the South Annex with Ms. Smith?
No, ma'am, she's the only one here.
All right,
Miss-
that's fine. All right, good afternoon. Are you Sharday Smith?
Yes, ma'am.
All right, Ms. Smith, your case is 22 CR 007046Y, in which you're charged with battery family violence with the offense date of October the 17th. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney today. This particular proceeding is being broadcast over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch it. Do you understand all of that, Ms. Smith?
Yes, ma'am.
All right. Mr. Howard, are you here? Will you please give us the history?
It might be a while with the jail. Is this Sharday Smith?
It
Yeah.
is.
First arrest.
All right, thank you. Mr. Howard, I'm sorry, you said it may be a while. What information do you have regarding the jail logging on?
Nothing is working. I don't know. They tried
Oh,
they
courtroom
redid
three.
everything.
I see
Okay, maybe
courtroom
they'll go to
3.
courtroom 3 then. Okay.
Okay, sounds good.
back here.
Okay. cool.
Wonderful,
They're about to
thank
come back
you.
here.
Okay, that works out. Thank you so much. All right, I'm sorry, Ms. Falk, is this your
Yes,
case?
Your Honor, it is.
Ms. Falk, please proceed.
Yes, Your Honor. The state's recommendation is a $4,000 signature bond through pretrial, no further contact with Jarmaine, that is Jarmine, Darren, Darren. Stay away from 4001 Lakemont Drive, no alcohol, drugs, or weapons, and 1 day anger awareness. This incident happened on the 17th of October at around 10:48 p.m. at that Lakemont Drive address. The officers initially responded to Rita, who was the caller, and Rita is the defendant's sister, and I have no last name or else I would not be calling her Rita, who had been, and the sister stated that the defendant had been involved in a physical altercation with Jarmaine Darren, her live-in boyfriend. Rita further told the police that the defendant had advised her that her ex-boyfriend attempted to assault her and her small children. When questioned, the defendant stated that Mr. Darren jumped on her and she bit him in self-defense. When Mr. Darren was contacted, he immediately said, oh, she called the police, and then said he wanted to press charges because she bit him and there was dried blood on Mr. Darren's right hand, which is what led the police to arrest her. Darren also stated that he had flipped the defendant onto her back, but that was just to get her off of him based on the bite. So we do have some concerns regarding this case, and that is the reason we're offering a $4,000 signature bond, which we normally would not do on a family violence battery, but because of the facts and circumstances, we would like to further investigate this before deciding how to proceed. And in that light, and the fact that she has no history, that is our offer.
All right, thank you, Ms. Falk. I appreciate that. I am going to sound for Mr. Darren at this time, just to see if he's on the Zoom conference and wishes to make a statement. All right, hearing none. Ms. Kim, do you have any objection to the signature bond, which I'm inclined to grant at this time?
Except that we don't have any objection to the signature bond, Your Honor, and yet the place 4001 Lakemont is actually her place, and she is in the middle of filing dispossessory action against her live-in boyfriend. So after dispossessory action gets settled and he gets evicted, I would like to make sure that my client can return back home.
All right. We will accept the state's recommendation in its entirety. And what we'll do is we'll indicate that once the once the alleged victim no longer resides at that location, she can return. Until then, she must stay away. She can return with one-time member of law enforcement to get her items for now. And then again, once the dispossessory goes through, she can return to her home. She is to complete the 1 day anger awareness. I will accept that part as well. And she is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further. Thank you very much, Your Honor.
All right, best of luck to you, Ms. Smith. And all right, we are now have everyone at courtroom 3. So we'll begin there. I see some private attorneys on the line. Ms. Rockwell, who do you represent?
And I'm not sure he's on the calendar, but do you have an Antoine Pierce, Pierce?
Can we take that position?
Yes,
Mr.
good
Pierce?
afternoon. Position number 15.
All right, good afternoon. Please, everyone pay attention. I'm gonna indicate the rights that you have. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney at this proceeding today. This particular proceeding is being broadcast over the internet. It is also being recorded. That means any member of the public can log on and watch this proceeding. Mr. Pierce, do you understand your rights here today?
Yes, ma'am.
All right, thank you. Mr. Howard, I see that it's first arrest, so we'll go straight to Mr. Tolle. Mr. Tolle, please give me the state's recommendation.
He's a resident of Mississippi too.
All right, thank you.
Yes, Judge, and I also wanted to inform you that this is a co-defendant case for position 22 as well. Judge, the state's recommendation is a $3,000 signature bond through pretrial services. Stay away from the incident location, 970 Mansell Road, and that's spelled M as in Mary, A, N as in Nancy, SELL Road, Roswell, Georgia, 30076. No further contact with the victim, Lorenzo Stewart, and no drugs, alcohol, or weapons while out. And Judge, in this case, on October 1st, 2021, the victim, Mr. Lorenzo Stewart, who is the owner of Distinguished Styles Barbershop, contacted the Roswell Police Department to file a police report. He stated that the two of his former employees, Dontarius Thompson, who is the other co-defendant, and Antoine Pierce, this defendant, worked at his shop for approximately 8 months. He stated that the defendants had recently fell behind on the booth rent. They had no intentions of paying, so he removed their items from the barber area so that it may be occupied by new barbers. Once the defendants were notified that their items had been removed, they went to the incident location and removed 2 chairs without consent. They were captured on surveillance cameras, removing the chairs from the barbershop. The chairs were approximately $650 each, totaling up to $1,300.
All right, thank you, Mr. Tolle. Ms. Rockwell, do you have any objection to the signature bond, which I'm inclined to grant at this time?
Judge, no objection to a signature bond, and that was quite reasonable of Madam Prosecutor. I do want the court to know that he does live in Woodstock now.
All right. All right, at this time, defendant will receive the $3,000 signature bond. I will send it through the jail. He is to have no contact with the alleged co-defendant in this case, and no contact with the alleged victim in this case. And he is to stay away from the address on Mansell Road and have no alcohol, drugs, or weapon as a condition of that signature bond. Is there anything further?
Judge, can I, if he just yes or no, make sure that they're not, he's a barber, so is the co-defendant. Can I just make sure that he and the co-defendant are not working together in a new place of employment? Could he yes or no that?
Yes, he can yes or no that.
Oh, no, ma'am.
I mean, you
right.
don't have contact with him, sir?
Talking about the owner of the barbershop?
The co-defendant, the other gentleman.
Yes, ma'am. He stays in Georgia. We moved up here together.
Okay, no, I guess, Judge, the question, is that going to be a deal breaker, Judge? I know it's confusing to
I would prefer that he not have contact. Is the defendant indicating that they live together or they're roommates?
They do not live together, Your Honor. The other defendant is my client.
All right, so we're gonna stick with the no contact between those two at this time, all right?
Understand.
All right. Ms. Rockwell, does that conclude your business today?
Thank you, Judge.
Yeah, does it conclude your business?
Yes, Judge, it concludes my business. Thank you so much. May I be excused?
Yes, you may. Have a great afternoon.
All right, thanks.
Are there other private attorneys on the line? All right. Who do we have next at the jail?
Position 8, no, not yet. Position 18, Shepherd.
All right, and I'd like to take position 7 last since Ms. Sari is asking for a breakout. So let's save that position for last if possible. All right, good afternoon, Mr. Shepherd. Your case number is 22 CR 0070478. I'm sorry, 7B, in which you're charged with battery, hindering a person making an emergency call, and reckless conduct with the offense date of October the 8th of 2021. Do you understand your rights today?
Yes, ma'am.
All right. Mr. Howard?
Yeah, he got an open case in Superior Court, 21 SC 179293. Possession of a firearm by convicted felon, theft by taking, 2 counts for possession of a knife or a firearm during the commission, theft by receiving, possession of marijuana with intent. Got 2010 harassing phone calls, 3 counts, that was accused. 2012 battery DV, cruelty in the third. The cruelty was a conviction. Ended up being aggravated battery, that was a conviction. What else? Hold on, Judge. Got a 2008 battery DV, reckless conduct conviction. I mean, disorderly conduct conviction. I think that's it as far as the violence. Yeah, that's it. He has a hold too.
What is it this case that's the hold?
It's in DeKalb County. It's an abandonment charge.
Okay, all right, thank you. Ms. Falk?
Yes, Your Honor. So this happened about a year ago in October of 2021 at 1192 Pryor Street Southwest in Atlanta, Georgia. The victim in this case, Keshondra, Keshondra Finley, F is in Frank, Inley, told police that she was on 75 northbound with the defendant, who is a friend, and that they began arguing. She stated the defendant who was driving began to drive recklessly. At that point, she told the defendant to pull over because it was her vehicle and to let her out. She also grabbed her phone to call the police. At that point, the defendant took her phone, tried to break it, and then smashed Miss Finley's head into the dashboard and punched her repeatedly in the face. After doing so, the defendant threw her out of the car on the side of the highway during rush hour, which is the basis for the reckless conduct, and then continued driving off in her car. Officers were on the scene, did observe a knot to the right side of her temple. Miss Finley also had a swollen lip and blood around her mouth. She later on contacted the police saying she did not want to proceed and admitted that she was pregnant with the defendant's child. We have attempted to reach Miss Finley by text and left a message with her, but we have not gotten a response from our victim advocate, has not received a response from Ms. Finley, but here is the state's real concern. The defendant actually is out on 2 cases in Fulton County. Pre-trial told you about 21 SC 179293, which he received a $25,000 surety bond on in March of 2021. On that case, he is now just indicted on the possession of firearm by a convicted felon. The other case he's currently sitting on is a 21 CP 198063 case, which was for aggravated assault, possession of a firearm by a convicted felon, and possession of a firearm during a felony, and theft by taking. He was released on bond on that case on a $26,000 surety bond in March of 2021. So basically from March of 2021 until October of 2021, he was already out on $51,000 worth of surety bonds when he committed this new offense involving not only slamming this woman's head into a dashboard, but essentially pushing her out of her own vehicle onto the highway. So what we have is a person with a very violent history, and that is also outlined by the aggravated battery, where he, in 2014, that was against 2 women, where he got a 4 years with 2 years to serve out of DeKalb County, and a battery family violence conviction in 2008. Not only that, he has FTAs from 2019 and 2017, and a 2013 probation violation conviction. He has 43 cycles which at this point, the defendant is 43 years of age. So literally as many cycles, as many days, as years he's been on this earth is as many cycles as this gentleman has. And a lot of his convictions are for violence, particularly violence against women and family violence battery. For those reasons, we are asking for a $5,000 cash bond. The breakdown is as follows: a $2,000 cash bond for the battery, $1,000 cash bond for the hindering, and $2,000 cash bond for the reckless conduct. And again, we have some serious concerns about his risk of reoffense. I mean, he's already reoffended in the time he's been out on 2 separate bonds, as well as his danger just generally to the community. Essentially, his history shows that the women he comes across do not fare well from their contact with him. That is all.
Thank you, Ms. Falk. Ms. McLeod?
Yes, Your Honor. My client is a native of Atlanta. He tells me that he is currently gainfully employed. I acknowledge that my client does have a history, Your Honor, but in this case, he tells me that he and the alleged victim were just having an argument, and he denies that he became physical with her at all. I would like the court to note that this incident happened, or it allegedly happened, more than a year ago. The two are not in contact. He tells me that they are no longer in contact. They have not been in contact since the incident. He doesn't know where she is. A $5,000 cash bond, Your Honor, is essentially no bond for my client. He's not in a position to post $5,000 cash bond. If the court thinks that a $5,000 bond is appropriate, I would ask the court to make that a surety bond and not a cash bond. Nothing further, Your Honor.
Your Honor, the state did leave out, there is no alcohol, drugs, or weapons, no further contact, and a stay away from the victim. And whatever address she resides at, we did not have a good current address for her. As well as 1-day anger awareness, if Your Honor deems that appropriate, even over top of the cash bond. And I will say he managed to post a $51,000 bond and get out to do this. So I'm sure he can post a $5,000 cash bond.
All right, I am going to sound for Ms. Finley on the chance that she is here with us today. I'm sounding for Ms. Finley at this time. All right, the defendant will receive a $2,000 cash bond broken down as follows: 1,000 count 1 and 500 on each of the remaining counts. He's to have no contact with the alleged victim, last name Finley, and stay away from the address where she resides. He is to have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further, Your Honor.
Nothing.
All right.
Your Honor.
All right, best of luck to you.
Position 22,
Okay, the 22 didn't bond out? I guess not. This is the case that was the co-defendant with position, the last position. Is
That's
that correct?
That's correct, Judge.
Okay, I had that he bonded out. All right.
Oh,
All
Your
right,
Honor, that was Mr. Teague, 21.
Oh,
Jarvis
21 is
Teague.
bonded out. Okay. All right. Thank you, Ms. Falk, for that point of clarification. I had scratched through this. Give me one moment. All right, Mr. Thompson, your case is 22 CR 007055F, and what you're charged with theft by taking with the offense date of December the 1st of 2021. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, I have it. This is first arrest, so we'll go straight
It is,
to
Your Honor.
the toll.
Yes, Judge. The facts are the same exact fact pattern for the co-defendant case, and the state's bond recommendation for this is the same thing: $3,000 signature bond through pretrial services, stay away from the incident location, 970 Manswell Road, Roswell, Georgia, 30076. No further contact with the victim, Lorenzo Stewart, and no drugs, alcohol, or weapons while out on bond.
All right. Unless Ms. McLeod has any objections, he'll receive the exact same bond that I gave. I'll send that 3,000 signature through the jail.
I do not, Your Honor.
No contact with the cross defendant or the victim in this case. No alcohol, drugs, or weapons. Is there anything further?
Nothing further from the state, Judge.
Nothing further, Your Honor.
All right. Best of luck to you, Mr. Thompson. That concludes your case.
Your Honor, that concludes my business before the court today. May I be excused?
You may, Ms. McLeod. Take care. Have a great rest of your afternoon.
Thank you, Judge. Same to you.
All right, bye-bye. All right, who do we have next?
We have position number 5, Gibson.
All right, good afternoon, Mr. Gibson. Your case is 22 CR 007045B, on which you're charged with battery, family violence, and cruelty to children in the 3rd degree, with the offense date of October the 1st of this year. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
This second arrest, last was November 2019, battery DV. It was non-process.
All right, thank you. Ms. Sowry?
Yes, Your Honor. This incident took place at 1912 Summit Springs Drive in Sandy Springs. Officers were dispatched to this incident location regarding a domestic dispute. The victim informed officers that while feeding their 3-week-old child, the defendant got upset because the child was fussy. The victim, whose name is Misha Lucas, that's MESHA, last name LUCAS, she informed the defendant to continue feeding the child so the child would stop crying. And that's when the defendant got upset, put the baby down, and then proceeded to push the victim up against the wall and informed her that he was not afraid to go to jail. The defendant then pushed the victim to the ground, and she sustained injuries to her forehead, chest, and her elbow. This defendant does have a 2019 battery family violence arrest that did result in a null prize that was a different victim, but he was given a signature bond through pretrial. So the state is recommending, due to his risk of intimidating the victim because they have a child together and his risk of reoffending, we're recommending a $4,000 surety bond. That's $3,000 on the battery family violence, $1,000 on the cruelty because this incident did take place in front of their child. No contact with the victim, third-party transfer of the child, and a 1-day anger awareness, as well as a stay away and no drugs, alcohol, or weapons. Nothing further.
All right, before I go to Ms. Armstrong, I'm going to sound for Ms. Lucas. Ms. Lucas, if you are present on the Zoom conference and wish to be heard, this is your opportunity to speak, although you're not required to make a statement. Okay, hearing and seeing none. Ms. Armstrong?
Thank you, Judge. For the record, Mr. Gibson reports having a private attorney. That attorney is not present to the best of my knowledge, nor does Mr. Gibson have his name. So that being said, he does not qualify for our services. I'm representing him only for today, but he has opted to work with our office. He has lived in the Atlanta area for over a decade. He is employed full-time as a property adjuster. And yes, this alleged altercation did begin because there was an argument about feeding the baby, the sterilization of the bottles to be specific. And unfortunately, there was a physical altercation, but my client reports that he acted in self-defense and that in fact, the alleged victim came at him with a knife while he was holding the child. And I am asking Your Honor to disregard this no pros from 2019. That was not a conviction, and that is not something that should be considered a bond in this situation. For all intents and purposes, this is my client's. He's never been convicted of anything, so I'm asking Your Honor to treat him as such and grant him a $4,000 signature bond with $2,000 on each charge.
All right, thank you. Anything further from either party before I make my decision?
Yes, Your Honor. I would like to bring to your attention that the defendant was not on the scene when officers arrived. So I would like you to consider that when making your ruling, please. Thank you.
May I respond?
Right. Very quickly.
Thank you. I'm not really sure what that would be the purpose of consideration. I mean, that's not a flight. He lives in Atlanta, so I'm asking her to disregard that.
All right. At this time, defendant will receive a $4,000 signature bond through pretrial, 3,000 count 1, 1,000 count 2. He must take the 1-day anger awareness course, have no contact with the alleged victim. He can arrange transport of the child through a third party, and he is to have no alcohol, drugs, or weapons. Is there anything further?
Your Honor, what was our bond amount?
It's 4,000 signature through pretrial.
Thank you.
Nothing further from the state, Your Honor.
All right. Best of luck to you, sir. Who do we have next?
We have position number 17, Mr. Rivers, Kendrell Rivers.
All right, good afternoon, Mr. Rivers. Your case number is 22 CR 007050C, in which you're charged with 1 count of battery family violence, 1 count of cruelty to children in the 3rd degree, and 1 count of simple battery family violence with the offense date of August the 12th. You understand your rights?
Yes, say something. Yes.
All right,
Okay,
thank
Your Honor.
you. All right, Mr. Howard.
Second arrest. Last was 2012, possession of marijuana. It was NOD.
All right, thank you. Ms. Falk?
Yes, Your Honor. This incident happened August 12th at 3440 Boulder Park Drive Southwest, apartment 202. That's the residence that the defendant and Miss Malam share, and her name is Jasmine, Jazzmyne, Malam, Milam. And actually, I misspoke. They do not share that residence, but they do share a child. So Miss Malam told police that the defendant, which was the father of her child, BR, struck her in the jaw with a closed fist and then placed her in a chokehold after they had an argument about her getting him food. He then attempted to take the keys to the car. Miss Malam told him he could not take those keys because the car was rented in her name. So after the argument progressed, it reached that point, at which point the defendant then struck her, which resulted in the strike to her jaw and the chokehold. Officers observed light scratches and bruising on the right side of her face. And Ms. Malam stated that when she reached for her cell phone to call 911, he snatched it away and told her that if she called 911, he would knock her out. The 4-year-old child, BR, did witness these acts and was present this happened in the presence of this child. And although the defendant only has 1 prior arrest and they are no longer in a relationship and do not live together, the state does still have some concerns about how this escalated and how it occurred in front of a small child. We are asking for a $3,000 surety, Your Honor, a $5,000 surety bond on this incident, $3,000 for the battery, $1,000 for the simple battery, $1,000 for the cruelty to child in the 3rd degree. No further contact with Miss Jasmine Malam. 3rd-party contact with the child, BR, and stay away from 3440 Boulder Park, Southwest, Atlanta, Georgia. No alcohol, drugs, or weapons. And we are requesting 1-day anger awareness. Thank you.
I'm sorry, Ms. Falk, will you give me that breakdown one more time?
$5,000 surety bond, Your Honor. That's going to be $3,000 for the battery, $1,000 for the simple battery, $1,000 for the cruelty to child in the 3rd degree.
Thank you.
Thank
All
you.
right, I'm gonna sound for Miss Jasmine Malam at this time. I believe I saw her earlier.
She is present, Your Honor. I know I saw her just a few moments ago.
All right, would you like to make a statement?
Since the incident,
Wait, before you start talking, you wish to make a statement. So please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, thank you. I just needed to swear you in before you start speaking. What I'm most interested in today is whether you wish to have contact with the defendant, but I will hear what you'd like to tell the court at this time. Please proceed.
I do like to continue to have contact with Kendrell. Since then, he has apologized. Our co-parenting relationship has become better. I have talked to him every day since. I just want you to take that into consideration. My daughter just had surgery, so that's why I would like to have all visits with him.
All right, thank you. I appreciate that. All right, Miss Kim,
Yes.
please
Yes,
proceed.
Your Honor. Yes. Kendra Rivers is 30 years old, Your Honor. He has lived here in Georgia for all his life. And of course, he has a child with Miss Jasmine, and they don't live together. So we do not object to the stay away as long as he can get a child visitation. And I don't think no further contact is necessary because this happened on August 12, 2022. There has been enough cooling period and the parties are doing well right now. My client actually is working at Marriott Hotel as a banquet houseman. He's been doing that for last 6 years, taking care of a child and paying for all that expenses. He graduated from high school. He also has some college credits for digital marketing as well. Since he had a car accident a few months ago, he does have some kind of special condition that he has to watch out for. He has to continuously meet the neurologist and he needs to have a medical attention, so which he cannot get it in the jail. And also this is one of the first violence case that he was involved. 2012, there was nothing to do with the violence, and I believe that he is qualified for signature on bond. So please, we request for signature on bond for his charges. Thank you.
All right, at this time, defendant will receive a $5,000 signature bond through pretrial. He is to take the 1-day anger awareness course. He is to have no further violent contact with the alleged victim in this case and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further.
Judge, break that down, please.
3,000 and then 3,000 count one and 1,000 on the remaining charges.
Thank you.
All right, anything further?
Nope.
No, Your Honor.
All right,
you.
best of luck to you, sir. Who do we have next?
Well, Hush.
All right, good afternoon, Mr. Hodge. Your case number is 22 CR 0070538, in which you're charged with possession of a pistol or a revolver by someone under the age of 18 with the offense date of October the 18th. You understand your rights?
Yes, ma'am.
All right, Mr. Howard.
This is second arrest. Last was back in March, theft by taking felony. Possession of a pistol or revolver by person under 18 years of age. Possession of marijuana. 22 CP is the case number. 22 CP 207580. That's all.
Okay, so that same charges as the charges here today. All right, Mr. Tole, please proceed.
Yes, Judge. On October 18th of this year, Officer Rutherford was assisting Georgia State Patrol units with canvassing the area of Lawton Street Northwest after a vehicle which they were pursuing stopped in the area while the driver fled. Officer Rutherford was advised by the troopers that a Black male matching the description of the driver was observed walking in the area. Officer observed him, stopped him, and approached him. The officer got his name and noticed that he was attempting to conceal a Black handgun, which was tucked into his waistband and on his right hip under his jacket. The state's bond recommendation is a $2,500 cash bond and no drugs, alcohol, or weapons while out. Judge, this defendant does run the risk of reoffending, considering that he does have an open case in felony court for the same exact charge, in addition to marijuana less than an ounce and theft by taking. That bond amount is a total of $11,000 surety bond. He is out. Well, he was out, and it has been shown that he can make high bonds. So as a result, the state will push for the $2,500 cash bond. And also for that open case, part of the bond conditions was for him to have no firearms, yet he did violate that on October 18th.
Thank you, Mr. Tole. Ms. Kim?
Yes, Ms. Hush is 17 years old, Your Honor. And he is full-time student at a high school. He's 11th grade. He has to go back to school, I believe. His favorite classes are math and reading, and he wants to go to college. He's getting ready for taking SAT and apply for college. And also he dreams to be wealthy enough to help homeless people in his town. Your Honor, he has father who I was able to speak to, Quinton Williams, who is willing to co-sign as soon as he gets a signature on bond. his father is disabled. So because of that, there's no way that he's going to be able to pay for any bond. And I'm concerned because his father was shot. That's how he became disabled. My client was very afraid. The only reason that he had a gun was, he says that it was to protect him from a sudden attack in that neighborhood. And I was very concerned to hear about that. He needs to get police protecting him as some kind of like a witness protection, and also so that way he doesn't have to feel afraid of walking around and being nearby. And also he has to go back to school. That's where he belongs, and he's got to complete his high school. We would like to request for a signature on bond, definitely not cash bond. That's way too much. So we would like to, he's also innocent, presumed to be innocent, Your Honor. Thank you. We would like to request for a signature on bond. Thanks.
All right, at this time, the defendant will receive a $10,000 surety bond. He is to have no alcohol, drugs, or weapons of any kind. And I'm sorry, Mr. Tully, was the state requesting a stay away of any type? I'm not thinking that that was requested.
No, Judge, we weren't. It's not specific enough. It was like on
I
the
didn't think so. All right. Anything further from either party? All right, best of luck to you, sir. Who do we have next?
14, Lester. He's gonna explain it to you.
All right. Good afternoon, Mr. Lester. Your case is 22 CR 007060J, in which you're charged with battery family violence with the offense date of September the 28th of 2021. Do you understand your rights?
Yes, ma'am.
All right. Mr. Howard, please begin.
16 total. Last arrest was 2019 probation. He's on probation for theft by receiving. 16 SC 148472. The underlying charges with the probation violations is terroristic threats, theft by receiving, ag assault with a deadly weapon. 2019, he was arrested on some CWAC charges. They were declined to prosecute. 2016 probation for those same felony charges. He was convicted for those in 2015. And before that was an 01 CWAC charge that he was convicted of. I put in check, and that's it.
Thank you. Mr. Torre?
Yes, Judge. On October 29th of 2021, the defendant walked into the Zone 3, the victim walked into the Zone 3 precinct to report that the defendant, who is also her boyfriend, assaulted her the day before. She stated that they were involved in a dispute. The defendant punched her several times in the face and kicked on both sides of her ribs, which caused small cuts to her left eye and swelling. The state's bond recommendation is a $7,500 surety bond. No further contact with the victim, Shiona Velasquez, and that's spelled SHEONNA VELAZQUEZ. Stay away from the incident location, 1019 Washington Street, Southwest Atlanta, Georgia, 30315. Completion of a one-day anger awareness course, and no drugs, alcohol, or weapons while out on bond. Judge, the state is concerned that this defendant runs the risk of reoffending, and he is a danger to the community, considering that he has convictions for aggravated assault, possession of a firearm or knife during the commission of or attempt to commit felonies. Also, 3 probation violations. And Judge, we have been in contact with the victim. She did admit to the facts that occurred on the incident date. Furthermore, she stated that that wasn't the first time that something like this happened. She also stated that they're in love and they live together, and we do anticipate that she will want contact, but based on the facts of this case and what she told our victim advocates, the state doesn't believe that having contact is in their best interest. I do see her on the Zoom call as well, and if you could sound for her when it's appropriate.
All right, thank you. I will hear from Ms. Velasquez at this point. If you would like to make a statement, Ms. Velasquez, please turn on your camera, raise your right hand so I can swear you in. However, you're not required to make a statement. All right. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, you can put your hand down. What would you like to tell the court at this time?
She actually called me under false pretense. I didn't know who she was, and I didn't tell her that we like this was a reoccurrence or either. That was also a lie. But I did tell her we do live together. He is a single parent. This happened a whole year ago. Since then, he's took a fatherhood. He's been in the fatherhood program, graduated. Like, we live together. Like, that's his address. There's no way we will not have contact. He's a single parent. His child is with me as we speak. Like,
Okay. I appreciate you making that statement. Ms. Kim?
Yes, Your Honor. Mr. Lester is 46 years old, Your Honor. And he was born and raised here in Georgia. And indeed he has 2 children. That's why he was involved in fatherhood program. He just had to go and pick up the certificate. He just graduated and he is very excited about this program. And because he was focused on the program, he has not been had a job for the last 2 months. So he's unemployed. He does not have any income to pay for bond at this point. His education is 9th grade. He dropped out at 9th grade. And he works before these 2 months, he worked at cleaning and landscaping to make a living for his children and the one that he has a full-time custody as well. We would like to request for signature on bond for this case. This happened more than a year ago. And of course, as we heard from Miss Shauna, they have a good relationship. They live together. I think they need to move forward and have a happy, healthy family. Thanks.
And Judge,
and very briefly, Mrs. Tolle, go ahead.
Yes, Judge, and if I may add, despite the length of time that has occurred between this incident date and now, the victim herself is the one who went to the police precinct and she reported this crime, more than likely because she was afraid. So as a result, the state would object to a signature bond.
All right, thank you. At this time, the defendant.
It wasn't because I was afraid, it was because I was upset.
Ms.
Actually,
Velasquez,
don't suggest.
Ms. Velasquez, please do not say anything else. The court has heard from you, all right? Thank you. I
apologize.
do appreciate you making that statement, but you cannot interrupt this proceeding, all right?
I apologize.
All right, at this time, defendant receiving $8,000 surety bond. He is to have no further violent contact with the alleged victim in this case and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further.
All right, best of luck to you, sir. Who do we have next?
10, house call.
All right, Mr. Husclaw, your case number is 22 CR 007052E, in which you're charged with no insurance with the offense date of July the 18th of 2021. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard, please give me the history briefly.
Okay, 38 total. Last arrest was in June, probation. On probation and card for 2 counts of shoplifting. Death by taking. I mean, I don't really see no insurance charges on here, so.
All right, I'm gonna hear from Mr. Tolle. I'm sure she'll give us the highlights. Mr. Tolle, please proceed.
Yes, Judge. On July 17th, the defendant was traveling south on Georgia 400 when he abruptly decreased his speed once he saw the police patrol vehicle pass him. The officer slowed his patrol vehicle, got behind the defendant, and ran his tag. Upon checking the Georgia registration tag through NCIC, it showed a status of being suspended and no valid registration. The officer also received an alert that the defendant had an active warrant out for his arrest out of Cobb County. The state's bond recommendation is a $500 signature bond through pretrial services, no driving without a valid tag and insurance, and no alcohol, drugs, or weapons while out on bond. And Judge, the defendant As far as his driving history goes, he does have a conviction for failure to obey a traffic control device and also a conviction for failure to maintain insurance.
All right, thank you, Ms. Satole. Ms. Armstrong?
We would not object to his signature bond.
All right, at this time, defendant will receive a $500 signature bond through the jail. He's not to drive without a valid tag or insurance. And I believe that will address the special conditions, no weapons, drugs, or alcohol. Is there anything further?
Nothing further, Judge.
All right, best of luck to you, sir. Who do we have next?
11, Horton.
Okay, Mr. Horton, good afternoon. Your case is 22 CR 007054B, in which you're charged with theft by deception with the offense date of October the 18th. Do you understand your rights? Yes. All right, thank you. Mr. Howard?
Horton, 15 total. Last arrest was in June, probation, not a card. He got an open case in Fulton, 2 counts of ag assault. 22 SC 182131. Also has history out of Mississippi and Iowa. 2020 suspended license, 2019 bail jumping conviction, 2018 violation of family violence order conviction, 2017 probation, 2017 FTA for driving while license withdrawn. Last arrest in Iowa was 2011. That was alcohol consumption. And 2016 in Mississippi, switching license plate, suspended license. Failure of owner or operator of motor vehicle to maintain insurance and careless driving. That's it.
Okay. All right, thank you. Mr. Tole?
Yes, Judge. On October the 18th, 2022, the victim sent the defendant $825 via Cash App due to him promising to obtain an apartment for her in Riverdale, Georgia. After the defendant received the money, he ceased all communication with her. He blocked her number without doing what was agreed upon between the parties. Judge, the state's bond recommendation is a $1,000 surety bond, no further contact with the victim, Faith Daramola, and the last name is spelled D as in dog, A-R-A, M as in Mary, O-L-A, and no drugs, alcohol, or weapons while out on bond. And Judge, the state is concerned that this defendant does run the risk of reoffending, also a flight risk due to being a multi-state offender. He has 2 open cases for aggravated assault in Fulton County, and that's 22 SC 182131, also 3 probation violations. And for that aggravated assault, case that's open, he has a $9,000 bond, which does show, and it proves that he can make high bonds, and he was out and he reoffended.
All right, thank you, Mr. Tole. I appreciate that. Ms. Armstrong, if you would proceed, please.
If I'm unmuted, thank you. Mr. Horton is not a flight risk. He maintains an address in the Atlanta area that is in the record of the court. He does live at that house with a few other people, and I did not hear any indication that he has a bench warrant in Fulton County. He most recently worked in the election field, but with the campaigns winding down, he's looking for a new job, and that's what he will be doing when he's out of jail. I'm asking Your Honor to disregard once again this note that he's a flight risk due to him being out and about the country. He does have an address here, and also I'm asking Your Honor to disregard any comment about his ability to make a high bond. Just because somebody can make a high bond once doesn't mean that they can do it again. Also, what Your Honor should consider, and I'm asking you to do so, is what is the appropriate bond to be set in a case based on the evidence that has been presented before you. And quite frankly, I don't see how the state's going to get very far with this case. This is an electronic communication. There's so much hearsay here. I'm asking Your Honor to set a bond no more than $1,000. Of course, I'm asking for a signature bond in this case, but if Your Honor's not inclined to do so, given the criminal history, no more than $1,000 based on the complete lack of evidence in this matter.
All right, thank you, Ms. Armstrong. I appreciate your advocacy. At this time, defendant will receive a $1,000 surety bond. He's to have no contact with the alleged victim and have no alcohol, drugs, or weapons as a condition. Is there anything further?
Nothing further from the state, Judge.
All right, best of luck to you, sir. Who do we have next?
9, Harden.
All right, good afternoon, Mr. Harding. Your case number is 22 CR 007051F, in which you're charged with 3 counts of cruelty to children in the 3rd degree, 1 count of theft by taking, and 1 count of battery family violence, with the offense date of February the 15th of 2020. Excuse me. Do you understand your rights here today?
Yes.
All right. Thank you. Mr. Howard?
I think he got bench warrants for this public drunk and criminal damage to property out of state court. So that's open, 19 CR 009 714F. Last arrest was 2019 criminal trespass.
Okay.
Trespass damage. He had a simple battery that was dismissed in 2017. Ag assault that was dismissed in 2013. 2013 probation violation, underlying charges burglary. The burglary conviction and possession of tools came in 2012. He got a theft by taking conviction from 04.
Okay. All right, thank you. Mr. Tolle?
Yes, Judge. On February 15, 2020, the police were dispatched to the incident location for a dispute call. When police arrived, the victim advised that her and the defendant, who was the father of her children, were involved in a dispute. The defendant became angry and punched her in the face multiple times, causing the victim to have a small laceration under her nose and upper lip area. The victim immediately called 911. While she was calling, the defendant took her phone and fled the location. Their 3 young children were in the family room during the incident, and all 3 of them witnessed this incident. The state's bond recommendation is a total of a $5,500 surety bond. For count 1, cruelty to children, $500 surety bond, no further contact with the victim, Javon Gates. Stay away from the incident location, 1994 Bent Creek Way, Southwest, apartment B004. Atlanta, Georgia, 30311, and no drugs, alcohol, or weapons while out. For count 2, theft by taking, $500 surety bond, no drugs, alcohol, or weapons while out. For count 3, battery family violence, $3,500 surety bond, no further contact with the victim, Wilderita Black, and her first name is spelled WIL, D as in dog, REYETTA. Stay away from the incident location. Completion of a 1-day anger awareness course, and no drugs, alcohol, or weapons while out on bond. For count 4, cruelty to children, $500 surety bond, no further contact with the victim, John Gates. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. And for count 5, cruelty to children, $500 surety bond, no further contact with the victim, Janiyah Gates, and that's spelled JAN as in Nancy, IYA. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. Judge, the state is concerned that the defendant is a flight risk, considering that he fled the scene after this occurrence. He also does run the risk of reoffending, considering that he has convictions for burglary and theft by taking. Also, he has arrests for simple battery, family violence, and 2 aggravated assaults.
All right, thank you, Mr. Tolle. I'm sorry, Ms. Armstrong, please proceed.
Thank you, Judge. Mr. Harden is 59 years old and he just had COVID. Being in the jail longer could be a death sentence with his age and the long-term effects that COVID has on people of his age. So I am asking you to take that into consideration. There's been no indication that my clients had any contact with the alleged victim in this matter. It also doesn't seem like the state's had any contact with the alleged victim in this matter. He is not a risk of flight because he, to quote Mr. Harden, sits at home all day with his grandkids and he lives with his daughter. I provided the court with an updated address where he can receive notice of his next court date. He receives SSI. He gets a check every month. So any monetary bond that is set in this case is going to be one he cannot make. This is an old case. I recognize that the judicial order extended the statute on this matter, but I don't I don't envision this case getting very far, and I'm asking Your Honor to consider that about having Mr. Harden sit in jail on a case that probably isn't even going to come to fruition. And with respect to any argument of flight risk, Mr. Harden holds himself out as having to get out of the house because this was a completely in self-defense. The complaining witness in this matter was intoxicated, and he needed to get out of there because she was at risk of hurting him in front of the kids. So he did what he had to do. He is not a flight risk. Thank you.
All right, I apologize. I did not sound for the alleged victim in this case, last name Gates. Is there anyone on the Zoom conference? All right, at this time, give me one moment to compute my math. I'm terrible at math. All right, defendant will receive a $2,000 surety bond broken down as follows: $250 count 1, $250 count 2, $1,000 count 3, and $250 on each of the remaining counts. He's to have no contact with the alleged victims in this case and stay away from the incident location. No, have no alcohol, drugs, or weapons. Is there anything further from either party?
Nothing further from the state judge.
He will be reset to that SAP calendar on the 1st, whereby this can be revisited. All right, anything further? Best of luck to you, sir. Who do we have next?
Position 8, Hammonds.
All right, good afternoon, Mr. Hammonds. Your case number is 22 CR 007039C, in which you're charged with battery family violence with the offense date of May 24th of 2022. Do you understand your rights? I'm sorry, do you understand your rights? I just need you to say yes or no.
Yes, ma'am.
All right, thank you. Mr. Howard?
County. All right, 11 total. Last arrest was October 13th for suspended license. He has that's open. He's on probation in Clayton County, carrying a weapon or long gun in unauthorized location. 2 counts of reckless conduct. 2 counts of carrying a weapon without a valid license. 2020 failed to appear. 2020 suspended license. 2012 probation was for driving, suspended license following 2 closures. And a 2011 suspended license conviction. He got an arrest out of Alabama. 2012 DUI. 2012 failed to appear.
All right,
That's it.
thank you. Thank you, Mr. Howard. Ms. Sowery, please proceed.
Yes, Your Honor. This incident took place at 875 Glendale Terrace, that's in Atlanta. Officers responded to this location regarding a fight. The officer spoke with the victim, whose name is Raymond, last name Huffstutler. He stated that he and the defendant were in the process of being evicted and bringing their items outside. The victim stated he wanted to distance himself from the defendant, and he walked across the street to sit on steps, and the defendant got upset, ran across the street, yelled at the victim, asking where were his keys to his U-Haul, and then proceeded to punch the victim multiple times in the face. The victim did sustain bruising from this incident. Your Honor, as we've heard from pretrial, the defendant does have FTAs in his history, one as recent as this year. He does also have a 2020 FTA and a 2013 FTA out of Alabama. So he is a flight risk. He does have probation violations, and he is a multi-state offender. The state's we were able to reach the victim. He is on the Zoom call. He stated to our victim advocate that he and the defendant never lived together. So we have amended this charge to battery, but he did state that the defendant had been violent with him in the past, and it's happened on numerous occasions. The state's recommendation is a $4,000 surety no contact with the victim, 1 day anger awareness, to stay away from the incident location, no drugs, alcohol, or weapons while on bond. Nothing further.
The allegation though, Ms. Ari, is that they were both moving out, so do either of them still live at that address on Glendale Terrace? Or is that the state's contention?
I am not sure. I can
Okay,
find.
that's okay. All right, I'm gonna hear from the victim. I believe the last name, you might need to pronounce it for me, sir, Mr. Raymond Huffstutler. I'm sorry. Please unmute your screen if you would like to make a statement. Do you wish to make a statement today? You're still muted. If you wanted to make one, let me know. You can nod your head if you don't wish to make a statement. All right, then we just need you to unmute so I can place you under oath. You're still muted. You'll have to press, there should be a small button that looks like a microphone somewhere on the phone screen. You press that and indicate unmute. All right. Let me look at my phone to see where it is. You're still muted, sir. If you would
I got it unmuted.
All right, thank you. Please raise your right hand for me.
Yes, ma'am.
Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, put your hand down. What would you like to tell me at this time?
All right. First off, the statements that were read had two small items that weren't quite correct. One is that it said that this had happened many or more than one time before. That's not true. It happened one time before, one and only one time, and it was not a terribly serious incident. No, for your information, Your Honor, neither of us live at that address, nor, just to make sure the court understands, did we ever live together. We lived in separate apartments at that address and were only acquaintances at best. Whereas the assault cannot be gotten around. I mean, it happened. I don't see that there is much productive to be gained by Mr. Hammonds being incarcerated. Anger management classes would behoove him a lot, but I also am given to understand that he is no longer associated with the person that he had been roommates with, and that person lied to him and told him that I had stolen their keys, and that was not true. And I believe without that mitigating catalyst, Mr. Hammonds would not have approached me and assaulted me. So I think I just, as the victim, as given that you're giving me a chance to speak, I would like to say that I think that it would be much more productive for him to be taking some anger management classes. I don't know that one day would do it, but certainly nothing productive would come, at least as far as this incident, by his continued incarceration.
All right, thank
and
you.
I don't think he'd be a flight risk. I don't think he poses a great danger. Anyway, I'm sorry, I babbled on too long.
Thank you. I appreciate that. Very thorough statement. Ms. Armstrong, please proceed.
Thank you, Judge. I'm asking you to follow the advice of the alleged victim in this matter and not keep my client incarcerated. This is a really complicated interpersonal issues are in this case that I don't want to get into, but I do want to I just want to let Your Honor know that. And also I did provide the court with an updated address. My client does not reside at the location as the alleged victim did state. My client and his partner at the time were living there. They were not being evicted. They were moving out. Part of the reason they moved out was because of the tension with this alleged victim. Like I said, I'm not going to go into the details of the interpersonal issues, but they were there. And so they were packing the U-Haul and the keys were missing. Whether or not there was confusion about how the alleged victim got them, if the alleged victim got them, my client was acting in self-defense because the alleged victim attacked him first. He hit him in the face with a cell phone. And so my client reacted as one would. And if any contact that my client made with the alleged victim was in self-defense, the police showed up. No arrest was made, and my client is in jail because the alleged victim files for a warrant for my client's arrest after the fact. So I want Your Honor to know that even when the police showed up, they saw injuries on both of my client and on the alleged victim, and they decided this is mutual combat, we're not going to make an arrest. So I understand my client has a history. I'm asking Your Honor to do the just thing and set a bond no higher than $1,000 in this matter. He is not a flight risk. 2012 FTAs, well, he will come to court. We've updated the court. And that's all I have to say. Thank you.
And Your
All right.
Honor, briefly, I'm sorry, I just want to make a comment regarding the victim's statement that this incident was not a big deal. However, he was evaluated by medical personnel and told that he would need stitches, but he did decline medical treatment. So there was something that happened. He needed stitches. So we are asking the court to ensure that $4,000 surety bond, and also due to the recent 2022 FTA. Nothing further.
All right, at this time, defendant will receive $1,000 surety bond. He is to have no further contact with the alleged victim, and he must stay away from the incident location. He is to have no weapons, drugs, or alcohol. Is there anything further? All right. All right, best of luck to you, sir. Who do we have next?
3 Brown.
All right, good afternoon, Mr. Brown. Your case number is 22CR007042Y, in which you're charged with committing certain prohibited acts in the rail or bus station with the offense date of October the 18th. Do you understand your rights?
Yeah. Yes,
All right, Mr. Howard, thank you.
36 total between Georgia and New York. Last arrest was 2019, ag assault, terroristic threats. He's on probation for that. It's 19 SC 173280. And that was on MARTA. 2017 possession of drug-related objects, NOD. 2014 forgery in the 4th conviction. Last arrest in New York. 2014 failure to pay service based on stealth. He was convicted for larceny. 2013. Possession of a controlled substance conviction, 2013. Another 2013 arrest. Intent to obtain transportation without paying. And trespass in the 3rd degree. 2012 possession of a controlled substance conviction.
I think that's good. Thank you, Ms. Howard. Ms. Howard, please proceed.
Yes, Your Honor. The current bond on this case is already set at 600 surety. The state is recommending that it remains as set with conditions to comply with MARTA, suspensions, no drugs, alcohol, or weapons while on bond. Your Honor, the defendant was seen entering into the train via the emergency door while the train was in motion, and he was detained. As we've heard from pretrial, there is a 2019 ag assault conviction that resulted in 5 years probation on MARTA, yet here the defendant is today regarding another incident on MARTA. So he does present a risk of reoffending. And again, we will consent to that $600 surety bond, nothing further.
Okay, thank you. Ms. Armstrong?
I find it difficult to understand the connection between ag assault and allegedly going through an emergency door. Judge, I'm asking Your Honor not to keep my client in jail for something like this. I gave the court an address where he can receive notice. I'm asking you to convert this to a signature bond of the 600. My client will report to court when called. Quite frankly, I mean, in my opinion, this is something that this should be citable, not confinable. I think there's better uses of our jail's resources than to keep somebody in jail for something like this. Thank you.
All right, I'm inclined to agree, Ms. Armstrong. Defendant will receive a $600 signature bond through the jail. He's to have no alcohol, drugs, or weapons. Did the state request to stay away, Ms. Sowry? I don't have an objection to him particularly staying away from that particular location.
Okay.
I'm sorry, you did, Ms. Sowry?
No, Your Honor. I just asked for him to comply with MARTA suspensions as they already put in their own stayaways.
All right, he must comply with any MARTA suspensions currently in place. Is there anything further? All right, best of luck to you, sir. All right, who do we have next?
Position 1, Bonnie.
All right, good afternoon, Mr. Bonnie. Your case number is 22 CR 007048E, in which you're charged with simple battery with the offense date of October the 18th. Do you understand your rights today?
Yes.
All right, thank you. Mr. Howard, may I please have the history?
Bunny, 11th adult arrest. Last arrest was in March for trespass, giving false name, misdemeanor possession of marijuana. 2018 shoplifting that was dismissed. 2021 failure to appear for shoplifting. 2018 shoplifting conviction. Another 2018 shoplifting arrest. 2017 misdemeanor terrorist threats arrest. Another 2018 shoplifting conviction. He got a burglary conviction out of Florida, 2009. That's it.
All right, thank you. Ms. Sari?
Yes, Your Honor. This incident took place on Edgewood Avenue. We are still investigating the matter. We currently only have the warrant, but what was reported was that the victim, whose name is Sunjin, that's Sunjin, last name Lee, she was punched in the face by the defendant for no reason. It does not appear that the defendant and the victim know each other. So this defendant is a danger to the community, as this was a random act of violence. We have heard the violent history of the terroristic threat that resulted in a guilty conviction. He does present a risk of reoffending. He has a 2021 FTA in his history, and he is a multi-state offender. So the bond is currently set at $2,500 surety. We are asking for it to remain as set with conditions of no contact with the victim, 1-day anger awareness course, and no drugs, alcohol, or weapons while on bond.
I'm sorry, Ms. Sari, the last name was Mead, M-E-A-D?
No, it was Lee, L-E-E.
Oh, Lee. All right, thank you. I'm gonna sound for Ms. Lee at this time. If you are present on the Zoom conference and wish to be heard. All right, hearing none, Ms. Armstrong, please proceed.
Yes, Judge. Mr. Bonnie reports being homeless, so any monetary amount of a bond is one that he is not going to be able to make. He denies that this happened entirely, and he acknowledges that he has no idea who Mr. or Miss or Lee is. There was no contact information made available to the defense, so we are not completely certain that APD has that. So there's sincere doubts that Mr. and Miss Lee will not appear before the court, but my client will. We do have his email address and phone number, and when his court date comes up, we'll let him know when that is. Unfortunately, there is no physical address, but my office will reach out to him to ensure he shows up. Thank you.
All right. At this time, the defendant will receive a $1,500 surety bond. He is to have no contact with the alleged victim in this case, and he is to have no alcohol, drugs, or weapons at this time. Is there anything further?
Nothing further.
All right.
Oh.
All right. Here. I'm sorry, sir. You have a question about the bond?
I'm
You can mask up for me.
I'm 100% SSI. I do not have a way, and I'm an orphan. I do not have a way of accumulating $150. My public defender told me that she would request a signature bond. I don't know.
All right. I understand. Please speak with her further regarding this. I'll reset your case to November the 1st, all right? All right, best of luck to you, sir. Who do we have next?
16, Reed. Oh, I'm sorry. Crane. I'm sorry, position 4, Crane.
All right, good afternoon, Mr. Crane. Your case number is 22 CR 007040J, in which you're charged with criminal trespass and fair evasion with the offense date of October the 18th. Do you understand your rights?
Yes, ma'am.
All right, Mr. Howard.
45 total Last arrest was on the 10th of this month for shoplifting. We went to the city jail for that. Before that was 2020 entering auto, dismissed. 2015 financial transaction card theft. 1, 2, 3, 4, 5, 6, 7 counts. 1 count giving false name, and 1 count theft by taking. All of those were convictions in 2015. Giving false name and obstruction from 2015. 2010 battery, terroristic threats conviction. 2008 simple battery conviction. I said he got 45 total, right?
You did.
No,
That's good. You did.
Excuse
All
me.
right, Miss Showers.
This Walter Reed, right?
This is no
Who is this?
Trevline Crane.
My bad.
4.
My bad. My bad.
I was like, he's 19. How is this possible?
I'm sorry.
You never
All right.
know, though. You never know.
I'm glad
Go
he said
ahead.
something though. Sometimes they don't even say nothing. Second arrest, last arrest was 2020, criminal damage to property, 2nd degree. It says closed when they pulled the file out of Canton, so it should be dismissed or whatever.
All right. Thank you. Miss Sowery, please proceed.
Yes, Your Honor. This incident took place at MARTA, located at 1055 DeKalb Avenue in Atlanta. The defendant was seen walking behind a patron and entering into the station without paying the required fee. The defendant's name was ran, and it came back that he had an active suspension that doesn't expire until November 14th of this year. Your Honor, the state is amenable to a signature bond. We request that it's $3,000 through pretrial, and to comply with any MARTA suspensions, no drugs, alcohol, or weapons. Nothing further.
All right. Thank you. Miss Armstrong?
Yes, Judge, we would welcome a signature bond. I'm happy to provide further argument.
All right. I don't think that will be necessary. I'm going to grant the $3,000 signature bond through pretrial. Wait, I'm sorry. The defendant is 18?
19.
19. Okay.
Wait,
So he
can we
won't need
confirm? I don't want to be wrong. Mr. Crane, are you 19? Just sound yes or no, if that's okay with Your Honor.
Yes. 19. All right. He will receive, I'm actually going to send it through the jail. He's going to receive a $3,000 signature bond through the jail. He's to comply with any active MARTA suspensions and have no alcohol, drugs, or weapons. Anything further? All right. Best of luck to you, sir. That concludes your case. Who do we have next?
What was the
16.
breakdown?
It's 15 each charge.
Come on, Mr. Reed.
I don't know what y'all doing.
Mr. Reed, have a seat right here.
Wait a minute, y'all just called my name.
All right, is everything
Yeah, I knew I
okay at
heard that
courtroom
name.
3? Is everything okay at courtroom 3? Is the situation well controlled? All right, Mr. Reed, I believe we have the history, but Mr. Reed, your case number is 22 CR 007056D, in which you're charged with loitering and prowling. I have the history as written, so we'll go straight to Mr. Tole. Please
Yes.
highlight though anything that you believe is pertinent, as we did hear a case between them.
Yes, Judge. In this case, on October 18th, 2021, the victim saw the defendant climbing her fence to watch her and her dog in the backyard. When Officer Hernandez approached, he observed the defendant matching the description given by the victim, drinking from a bottle of wine on the sidewalk. The victim was able to provide video footage and confirmed the defendant was the male that was looking over her fence into her secured backyard. The state's bond recommendation is a $1,000 surety bond. Stay away from the incident location, 867 Myrtle Street Northeast, Atlanta, Georgia, 30308. No further contact with the victim, Sophia Netuno, and that's N as in Nancy, ETTUNO, and no drugs, alcohol, or weapons while out on bond. As you did hear from pretrial, this defendant has a total of 44 cycles. And as a result, it shows that he runs a significant risk of reoffending.
All right, thank you. I'm sorry, Ms. Kim, please proceed.
Yes, Your Honor. Mr. Reed is actually 67 years old, Your Honor. And he has actually he's been disabled and he gets disability checks. So he has a very limited income source, and $1,000 is kind of like having a no bond for him. So he has to sit in the jail for another couple weeks for SAP calendar. I would like to request for a signature on bond and let him go. So that's my request. Thanks, Your Honor.
All right, at this time, defendant will receive a $500 surety bond. He's to stay away from the incident location and have no alcohol, drugs, or weapons. Anything further?
Thank you, Your Honor.
All right.
Position 7, Gray. I got you.
All right, this is the case that a breakout was requested. Can we please go into the breakout? I believe it would be Ms. Sowery, Ms. Falk, myself, and I'm sorry, who represents Mr. Gray? Ms. Kim?
Ms. Armstrong.
Oh, Ms. Armstrong. Ms. Kim is welcome to join if she would like to be part of the breakout as well.
Thank you, Your Honor.
All right. Mr. Howard, if you would put the history for Mr. Gray onto the record, we would appreciate it. Is Mr. Howard with us? Mr. Howard?
I'm here.
Can we
I
have
didn't know
it?
you were talking to me.
Yes, I'm
Um,
asking you for the history, please, for 7.
oh, I put it up. I thought you got in the breakout. Hold on. For Gray?
Yes, please.
Oh my, yeah, he got a lot. 68 total.
Okay, we're most interested in prior criminal trespass.
Judge, I didn't dissect it like that.
Okay,
Cause he got a lot out of Florida.
And I can briefly put the criminal trespass.
yeah, that's fine. Ms. Howard, please go ahead. Please briefly put it on as well as the state's recommendation.
Yes, Your Honor. This defendant has a 2016 disorderly conduct obstruction conviction, 2021 criminal trespass obstruction conviction that's out of Athens. He does have 58 total cycles out of Florida within the last 4 years, a 2018 criminal trespass conviction, 2019 obstruction, possession of cannabinoid, and 2021 FTA. The state's recommendation is a $600 surety bond. It's already set. We're asking for it to remain as set, with conditions of an MHET. Stay away from the incident location, which is 640 Peachtree Street Northeast in Atlanta. That's the Courtyard by Marriott. And no drugs, alcohol, or weapons while on bond.
All right, and Ms. Armstrong, do you have any objection to that recommendation?
I will say I object to getting an evaluation being a condition, because if for whatever reason the evaluation isn't consented to by my client, I would hate for that to be a condition that would keep him in jail or to be a bond violation. I'm going to file the order to get the eval done, but whether or not he wants to speak with the care provider, that's his choice. So, and he might not even be in a position where choice is what we think about choice being. Does that make sense? So I'm just asking for that not to be a condition, but I am filing for the order for the evaluation again.
I'm gonna make it high enough so based upon the information before me, it seems that evaluation is necessary. So I'm gonna order a $5,000 surety bond. I'm sure that will be adjusted at some point in the near future, and I'm gonna order the order as discussed in breakout. He's to stay away from that incident location. Is there anything further?
Is he going to the competency calendar or to the SAP calendar?
He's going to SAP for now.
Okay.
Is that Tuesday or Thursday? I'm sorry, Miss Bridgewater. Is that a Tuesday or a Thursday?
It's gonna be Thursday. The next one is Thursday, November the 3rd.
Okay, so if he could be put on that Thursday, November the 1st competency, that would make sense. So it's the same day. I want to make sure.
November the 3rd to the competency calendar. Okay, that's when his next
All right.
court date will be. Okay.
Yes, we'll do that. All right.
Judge, I
Thank
got
you,
a
Miss
quick
Bridgewater.
Uh-huh.
We're ready.
Okay, position 2 bonded out. Position
right.
21 also bonded out.
And 13 waived appearance.
Position 6 waived their appearance. Let me check 13. Position 13 is upgraded to a felony.
Okay.
And also position 19 waived their appearance.
All right.
And
So
we're
we'll just, all right. You all have a great rest of your afternoon. Take care. Despite all of our difficulties, we still finished in really good time. Y'all take care.
Yes, we did. Thank you, Judge.
Your Honor,
All
we
right.
still have a case with PD Kim that was a waiver.
Right. No, I'm letting courtroom 3 go, but
Okay. Thank goodness.
we're gonna keep rolling here, Miss Falk. I'm not letting you go. I'm just letting courtroom 3 go. All right, Miss Kim, you waived.
I have a question though, before we go any further. There were 2 people that she said bonded out. What were those numbers again? Those
I have
positions?
position 2 bonded out, and I think the other one was what, 21?
Yes.
2 and 21. Okay, very good. All
And
right.
just for the court certification, Tyshawn Hurt, the CP number, position 13 is 22 CP 213294.
Okay.
I'm
And he was
surprised it
upgraded
actually,
to felony.
yeah, I'm surprised it popped up on the calendar. He was upgraded before 9 a.m. So
No problem.
All right.
Okay,
it's not,
thank you.
not a biggie.
I'd
Okay,
rather him be
thank
here
you.
than not, so that's actually really good that he appeared. All right, in the case of Antoine Sims, 22 CR 007049Y, defendant is charged with 1 count of criminal trespass and 1 count of certain prohibited acts being conducted in a rail or bus station. Ms. Kim, you're waiving his appearance. I'm assuming he's in medical, but you've had the opportunity to speak with him and submitted your waiver.
Yes, Your Honor.
All right, thank you. Mr. Howard, please proceed.
Sims, 56 total. Last arrest was February probation. On probation for identity fraud out of Coweta County. 2014, they gave him 9 years probation. 2021, theft by shoplifting. 2021 probation. Another 2021 probation. And another one. 2020 probation. 2019 probation. 2018 interference with government property. 2018 FTA possession of cocaine. 2018 trespass conviction. 2018.
I think we've got the general essence here. I'm sure Ms. Falk will fill us in. Ms. Falk, please proceed.
Your Honor, this happened October 18th. The defendant was observed walking on the tracks at Civic Center Station, and he had a MARTA suspension that was active. It was dated September 14th, but took effect October 14th of this year. So he was 4 days into his suspension when he was found walking on the train tracks, and for that he was arrested for criminal trespass and for prohibited acts. So the defendant does have just a lengthy litany of probation violations. I went through the entire GCIC, but just took into account the last 10 cycles or so. He had that 2018 conviction for criminal trespass at Publix. He has a 2021 Doraville drug objects arrest and several probation violations, as well as a 2021 theft by shoplifting from Fulton. The probation violations that I could count from 2020 to today were 1, 2, 3, 4, 5, 6. The bond was currently set at $1,200, which is $600 surety bond for each charge. We are agreeable to reducing that to a $500 surety bond, $250 on each charge. Stay away from MARTA at Civic Center Station, no alcohol, drugs, or weapons. I know this is a criminal trespass and a violation and prohibited acts. However, the defendant has shown he is kind of not great at doing what is being told to him by the courts. The probation violations are stacking up, and I don't exactly trust, especially being that he'd already received a criminal trespass, that he is going to stay away from that location. Thank you.
All right, thank you. Ms. Kim?
Yes, Mr. Sims is 42 years old and he lived here in Georgia for all his life. Right now, he is unemployed. When he is employed, he works at ceramic tile and painting at the construction site, home remodeling. His education was up to 10th grade in high school, and he does have a very serious medical condition, chronic, and it's fatal. I'm just very concerned about the condition of his medical condition that may expose him to COVID-19 in a more vulnerable manner. So we would like to request for a signature on bond on his charges. Thank you.
All right, defendant will receive a $2,000 signature bond through the jail. It will be $1,000 for each charge. He must stay away from MARTA and comply with all active suspensions and have no alcohol, drugs, or weapons. Is there anything further?
Nothing further, Your Honor. Thanks.
All right. I believe Ms.
Thank you, Your Honor.
All right. I believe that concludes the calendar. Ms. Bridgewater, will you please review it for us?
Sure, just one moment. Okay. Let's get through this. Once again, the reset date for the SAP calendar is going to be November the 1st. Okay, position number 1 is going to the SAP calendar with a $1,500 good bond. Position 2 position number 2 was released. So therefore, it is going to be reset further notice. Position 3, reset further notice with a $600 SOB through the jail. Position 4, reset further notice with a $3,000 total SOB through pretrial. Position 5, reset further notice with a $4,000 total SOB through pretrial. Position 6
Hey,
is
hold on,
going
hold
to
on,
the
hold on, hold on, hold on, hold on, hold on. Number 4 is jail or pretrial?
I have jail.
I have, is it going to the jail?
Yeah, I thought it was jail.
You changed it
It's
to
a jail.
Okay.
It's through the jail, yes.
Okay, I got you. Okay, we're going through the jail.
Okay.
I mean, not literally going, but through the jail, okay? Okay. Position 5, reset further notice with a total $4,000 SOB through pretrial. Position 6 is reset to the SAP calendar with a $4,000 good bond. Position 7 is going to the competency calendar on November the 3rd with a $5,000 good bond. Position 8 is going to the SAP calendar with a $1,000 good bond. Position 9, the SAP calendar with a $2,000 total good bond. Position 10, reset further notice with a $500 SOB through the jail. Position 11 is going to the SAP calendar with a $1,000 good bond. Position 12 is going on the SAP calendar with a $10,000 good bond. Position 13 was upgraded to felony. Position 14 is going to the SAP calendar with an $8,000 good bond. Position 9, I believe he was one of the co-defendants. I think it was $3,000. I have it somewhere, but I'll come right back to it. But it was a $3,000, I want to say SOB through pretrial.
Am I from
Am I correct
15?
on that?
Number 15?
Position 15, yes.
I got jail.
Okay, $3,000 SOB through the jail? Is that what you're telling me?
For pretrial, but I mean.
And I
No,
have
they both
as
went
well.
For
I have
number
through the
15?
I have through the jail. It's through the jail.
I have a $3,000 SOB through the jail. Okay?
Yeah,
Is
the
everybody
jail.
with me on that one? Okay, good.
I'm
Okay,
with you,
position-
Ms. Bridgewater.
Thank you for being with me.
I'm with you.
Position 16 is going to the SAP calendar with a $500 good bond. Position 17, this is, okay, I'm gonna come back to that one too. You all were making me write real fast this
I
morning.
got
but I'll come back
5,000
to it
pretrial for that one.
with a breakdown. Yeah.
Yeah.
3,000 on the first charge and 1,000 on each other charge. Am I correct? There were 3 charges.
That's
Either way,
what-
I'll come back.
That is what I have. 3,000 on the battery, 1,000 on the remaining charges, 5,000 through pretrial.
Thank you. Position 18 is going to the SAP calendar with a $2,000 total cash bond. Position 19 is reset further notice with a $2,000 total SOB through the jail. Position 20, reset further notice with $4,000 SOB through pretrial. Position 21 was released, therefore it's being reset further notice. And position 22, reset further notice with the $3,000 SOB through the jail. Are there any other questions, concerns, or comments? And we did do it in good timing. Okay?
All right, everyone, hearing no further comments, changes, corrections, or questions, we will be in recess until tomorrow's SCA calendar. Everyone take care, enjoy, have a good rest of your afternoon. Bye-bye.
Yes. Yes, Ms. Armstrong, will you please send me that order, please?
Yes, I'm working on it right now. Thank you, Mr.
Okay,
Turner.
great. Take care,
All
everybody.
right, take care.
Bye-bye.
Bye-bye.
Bye.